Lords, can I keep this as brisk as possible? First of all, on limitation, first point on Etsy, we don't really detect that the point on the Supreme Court that we made in relation to the background to Etsy was really challenged. Our submission is that if there is a practice, it shouldn't be departed from. In relation to the existence of the practice, my lords were referred to TCL against Ericsson, which was a case which actually showed what the practice was. Because as my lords will recall from that case, even though there may have been some complexities, we probably don't need to go into for this case as to the precise timing of the date from which limitation apply. There was no doubt that the court took account of the fact that significant parts of the claim were time barred. Indeed, the passage that my lords were referred to in TCL and Ericsson worked on the premise that my argument in essence was correct, that should be taken into account. The judge, as my lords have seen, said that the question for him was whether the practice should be solidified, thereby recognising that there was such a practice. And of course, the expert evidence in this case was all put forward on the basis of the 2013 date, and we know that IDC's practice was to regard claims 6 years before the relevant date as being time barred. So in our respectful submission, all of the material was one way on this, and my lords would be departing from that by accepting the invitation extended by my learned friends. In relation to reasonableness of that approach, I didn't detect an argument that that approach was unreasonable. It was said that it ought to be changed, but that's a very different matter from saying that it was unreasonable for that practice to have existed. I referred my lords to the Chagos cases, where you see the courts there explaining why it is that there is that policy, and the circumstances, which are very limited, in which limitation, even in what might be called a really meritorious case, might be disapplied, and both the High Court and the Court of Appeal explaining why that simply couldn't be done, and saying that it was obvious that Parliament didn't consider that the English laws on limitation were contrary to its public policies. Why should this court consider that those negotiating FRAND agreements should regard it as unreasonable to do something that is contrary, to do something that is in accordance with the public policies of many nations? My lords I don't think receive a direct answer to the point that, of course, the Etsy policy says that if there is no agreement that can be reached, the remedies are for national courts, which rather suggests that in the Etsy framework, there isn't an approach that recognises that it's appropriate to apply a completely different approach when it comes to quantification for that would apply in national courts, albeit recognising that there are differences in what one is doing with a FRAND negotiation and a damages situation, but not suggesting that there's any real basis for departure from that. The next point is that we respectfully submit that shows that the practice is based on reasonable policy, and that there's no reason to depart from it. Next point in relation to behaviour, of course, my lords have got all the points on this, and my Lord Justice Arnold summarised the position very well. Our position on this is, first of all, that the claimants behaved in an unreasonable way by making demands that were not only super-FRAND, but very significantly super-FRAND, based on a programme that the judge analysed of having rates that simply couldn't be justified. And this is not just a situation where it was just us saying that. My lords may have in mind that prior to the litigation starting, the IDC themselves recognised that the rates they'd previously been demanding were not reasonable, and indeed they did a very significant adjustment in our submission, an insufficient adjustment, and ultimately the judge held that the adjustment was insufficient. But this was not one of these situations where, in a sense, by the time of trial, reasonable people could differ that the approach that had previously been taken by IDC was an unreasonable approach, and you find that set out in Mr Merritt's evidence, and it's recorded in the judge's history. So while there are situations, and my lords may have them in mind, where one can say, well, licensees don't behave in an optimal way. And doubtless that has happened in some cases. This is a case the other way round. This is a case where a licensor, perhaps not facing the pressures that some licensees face of being a manufacturer as well, and therefore having to look at things on both sides, which some people in this industry have to look at. IDC is a classic non-practicing entity, and because of being a non-practicing entity, in a sense, that there are no constraints on its conduct in asking for very significant sums, because it's never faced with the contrary arguments against it, saying, well, if you consider this approach to be appropriate for you, then we consider it appropriate for us as well. So that's the first point in relation to super-fran terms. These were really extraordinarily high by their standards themselves. The second point is in the adequacy of information, and my lord has that point, but there is a third point on conduct, which in all respectful submission is important in this case, because this is not just a situation where someone is asking for massively inflated rates or providing inadequate information. This is a situation where IDC was seeking to stop us having a FRAND license altogether based on a completely unjustified case that we had been in the wrong in our approach to conducting negotiations, when in fact the judge held to the contrary. So for those three reasons, which in my respectful submission don't apply in every case, this is a case at the extreme end of a conduct which should be reflected at points where conduct can be reflected in this context. The next point was who should sue in this framework if agreement hasn't been reached. And in our respectful submission, we say, well, either party can sue. In this case, IDC could have sued. They were complaining about us. And I think it was rather surprising for Mr. Chacksfield to make this proposition, because what the complaint was that we should have sued them in circumstances when their position was that there shouldn't be litigation and that negotiations should continue. And so the very reference that he gave to that point shows in the very next sentence afterwards in the skeleton in question that was the position that was being taken. It said, oh, well, there should be a volunteering of some arbitration mechanism. Well, we agree, arbitration, to this extent, arbitration can be a remedy, but as my lords will know, it takes two to tango on this. We put forward a dispute resolution process which had the advantage of being open, and it had the advantage in some senses of blending the approach of more than one tribunal. We're not saying that's the only approach. Ultimately, we accepted that the English court had done matters in a reasonable way, but the approach that we were taking was not an unreasonable one. Indeed, it was a tweak on what was ultimately put to us by IDC as an appropriate approach, namely having the dispute resolved in the United States, but with folding in the Chinese proceedings. I don't think my learned friend really addressed the point as well, that it was not until relatively recently that in any jurisdiction it was possible for there to be a preemptive claim of a general kind, saying we want a valuation of this portfolio. We are dealing with a situation which is developing at the moment. I'm not even sure that IDC accepts to this day that there is an independent jurisdiction that arises in this country for a manufacturer faced with a claim for royalties to say, right, we're unable to agree. We think, for example, as would be the case in the Copyright Tribunal, you've got an expiring license. A licensee can say, under the statute, it is unreasonable that this license should cease to remain in force, and therefore I want to make a reference to the Copyright Tribunal for an extension of the license on existing terms or such terms as may see fit. If there was such a general jurisdiction, which was unquestionably accepted.
The problem with this aspect of the case is it all depends. So, for example, if an implementer comes to court seeking a declaration as to what is a FRAND rate, much depends on the basis upon which it is sought. If the implementer says, we accept, we need a license, and we will take whatever licence the court determines pursuant to our declaration, then it's difficult to see why there wouldn't be jurisdiction.
Yes.
If, on the other hand, the implementer comes to court and says, we just seek a declaration as to a Fran rate, but we do not bind ourselves to accept the determination, then there's a strong argument there's no jurisdiction.
Oh no, I entirely accept what my lord is putting to me. But my point is perhaps a slightly different one, which is that the debate that that we're having in that interchange is one that we're having in 2024, after there's been a significant development of jurisprudence in this area, including in relation to the unwired.
I'm sorry, it's all based on the utility of a declaration.
Oh, indeed.
It's jurisprudence which goes back 20 years.
Indeed, and I entirely accept that. But my point is this: it is a developing jurisprudence, and it is not even clear that IDC would accept this proposition, that if we came to the English court and said we accept all of the terms that my lord has indicated, but there is one thing that we would add to this, which is that pending the resolution by this court as to what the fair terms are of a license, you should not seek injunctions against us in other jurisdictions so as to undermine the process of the English court. It's not clear that IDC would say, oh yeah, we accept that. But that is the basis, for example, upon which the Copyright Tribunal jurisdiction operates in relation to expiring licenses that are due to expire. So we have a situation where unless it is clear that an SEP owner is not going to use alternative means to try and undermine a finding of this court, even in circumstances where undertakings have been given, this doesn't provide a proper remedy for a manufacturer, unless one gets into the territory of saying, all right, in these circumstances we're going to have anti-suit injunctions and so forth. So my point, though, is a much more limited one, which is whether in the toing and froing in relation to this, it's right to say that we should be criticised for not suing in circumstances where they were suggesting that actually negotiations should continue. Next point on Section 29 of the Limitation Act, that simply has no application. Section 29(6) provides for limited circumstances in which acknowledgement will retoll a limitation period. No one suggests that that's reflected in any of the relevant analogies, or that is an appropriate basis upon which to proceed here, or that anyone has ever proceeded on that basis. In fact, I don't think that is a point that has ever been made until the arguments in the Court of Appeal in this case, which rather suggests that there is no substance of that being in any sense a basis for saying that there's an analogy of cases of this kind. Final point on this aspect relates to incentives and the policy. And what's said is that if you apply a limitation approach, that will result in incentives to implementers to drag things out and try and take advantage of the limitation period. There are 2 points that in relation to that. First of all, that is something that can easily be brought to an end by litigation, and particularly now can be brought to an end by litigation. And, as we know from IDC's own conduct with respect to the United States, was brought to an end in relation to other licensees, but was not even attempted to be brought to an end with respect to us. And that shows that they may have well had very good reasons for preferring not to bring these proceedings at an earlier stage. This is not a situation of delay, because recall they brought a number of other people into court. They didn't sue us in the United States and in the ITC, and they could have done at an earlier stage. So we respectfully suggest that this is an argument which should be looked at with some caution. But there is another side to the argument which is just as important.
Can you get damages in the ITC? I thought it was. Can you get damages in the ITC? I thought it was just an exclusion order.
I think it is an exclusion order, but then of course you can sue in the United States courts for damages. But my lord is right to raise that point. But one might say an exclusion of, as it were, the old IBM's products from cellular ones from the United States is not an irrelevant consideration.
Sure, no,
to one of the most important manufacturing and research-based companies in history, actually. So the final point in relation to this is approach. If my lords accept my overall proposition, which is that it is not unreasonable for the parties to have proceeded on the basis of the, albeit approximate 6-year period that we have in this case, the approach that I commend to my lords deals with this, and it deals with the incentives on both sides. First of all, the primary approach should be the TCL and Ericsson approach, the industry approach, that limitation is something which it is reasonable to take account of in the way that we have suggested. The secondary point is that if, for any reason, the industry considers that to be wrong, ETSI can deal with it and give guidance that this can be extended if appropriate and the practice changed. But if there are exceptional cases where it is clear to a court that a defendant has been behaving in a way that has unfairly deprived the claimant in one way and another of remuneration, and it would be unfair to rely on the limitation period, unconscionable, I think is the word in some of the cases, then the court can, if it wishes, bearing in mind that this isn't a not statutory jurisdiction which provides for exactly the same provisions as Section 28 on extension of the limitation period in this country. In those circumstances, it may be that the court would say, well, a willing licensor or unwilling licensee would have recognised the, in a sense, misconduct on the part of the licensee and would have reflected that in an agreement. But for it to be the other way round is, in our respectful submission, a significant departure. So that's all I want to say in relation to limitation. In relation to interest, could I just re-invite my lords to just briefly consider the Huawei and ZTE proposition, because it does underlie a number of my submissions, and my learned friend didn't go to it. It's in bundle 3, I think. Four. My apologies. No, it's bundle 4. 47. Paragraph 67. I think what was suggested by my learned friend was that the approach that should be taken in a kind of ideal world is that once there'd been an approach, and the question may be which way round, but once there had been an approach, what a alleged infringer should do at the point at which the counteroffer is rejected is to provide appropriate security in accordance with recognised commercial practice. So the primary obligation is to secure royalties. It is not to pay the royalties over, it is to secure them. Secondary point, in the field, for example, by providing a bank account or by placing the amounts necessary on deposit. Calculation of that security must include the number of past sales. The alleged infringer must be able to render an account in respect to those acts of use. Well, let's suppose, my lord, that we had done that at any relevant date. You can take whatever date you like. And we had taken the money notionally that was subsequently awarded as a sum, taken it out of our general cash or whatever, and placed it either in circumstances where it could be used as security or put it into a bank account where it raised interest, because the idea would be that it would be ordinary bank account, one would assume, secure. What would have happened in relation to that? The sum in question would have accrued interest, but it wouldn't have accrued interest at the rate in question. You decide completely the time.
Just before you go on to the rate, this argument amounts to an acceptance that interest would be fall due.
Oh no, I understand that.
Because your primary argument is that there should be zero.
My primary argument is that there should be zero, and I'll come back to that primary argument. But I want to come back to this argument first of all, because of the level at which that interest would be if we had followed the Huawei and ZTE approach. And you find that in Mr. Mellor's evidence. It's supplementary C at tab 16, where essentially in his calculation, and just pausing there, we were criticised for putting this material in. There was no expert evidence on the other side in supporting their approach to interest. All of the points that you've heard were put forward on the basis of submission, and in a sense trying to use this material against us. But what Mr. Mellor did, in a sense we say completely fairly, did a calculation as to what would be the notional uplift if the money had been placed on account. So one can see this as a I've described it now as a Huawei and ZTE payment. And the sums are really very small. It's true that they are not zero, but if you look at paragraph 13, which is a money market interest-bearing bank account, insured in the appropriate way. So this is, in a sense, security for interest. You find that the sum there is 0.66 million. Now, I'm not saying that is zero, of course, my lord. But what I'm saying is that that on the facts of this case, if what had happened was what my learned friend said should have happened, the sum, bearing in mind the variability, what might be called the rounding errors in this case, would have been as close to zero as makes no difference. And for it to be said in this case, which is my learned friend's case, that the level of interest which we should pay is $50 million, nearly $48 million more than the level of interest that we should have paid if we'd followed the guidance of the European Court of Justice in relation to these matters, is, we respectfully say, out of line with reasonable practice. And my lord, coming back to the point in relation to that, our primary case is that there should be no interest. But if my lords are against me, our case is and was that the interest cannot be properly justified at the level at which, and for the rates and the period that the court sought to advance. My learned friends referred to Sempra and said, oh, well, this is a case that supports what might be called restitutionary interest. Well,
No. That was what was overruled.
That's the point I was going to make.
But as was pointed out, it remains good law as far as debt, contract and tort are concerned.
Oh, no, I understand that, my lord. But my point is this. Let's assume, against me for present purposes, that interest is properly payable on a basis recognised in the industry. We say there is no such recognition, and it would be completely novel, as I'll come on to with the agreement. But let's even assume that your lordships say that interest should be paid on a Huawei and ZTE basis, namely as it were security interest. And my lords, we did provide security on request at a level of $10 million. That was the sum asked for us during the course of litigation. We provided it. No one ever suggested that it should be increased during the entirety of the litigation. There was no request for an interim payment on account at any point in this litigation. So we did what we were asked to do. And if my lords think, okay, well, you did what you were asked to do, but the one thing you didn't do was put the money into a bank account separately in accordance with this guidance, we accept. We didn't do that. But that gets nowhere near the sums in interest with which we are concerned in this case.
Mr. Alexander, you've said nowhere near a number of times. I'm looking at Mr. Mellor 4, tab 16, and the Bank of England base rate number. And noticed, I hadn't noticed this before, that it's stated as from November 2018. So the figure there, which I don't think is confidential, is it confidential? No, is about $9 million. If it's $9 million at the bank rate plus 1% from 2018, I know the bank rate was much lower in the past, but I'd be surprised if the number counted in the way the judge did it. Certainly it would be double it.
Well, we can certainly
You're getting close to 20 million. I would have thought it might be quite a bit more than that. I'm just doing it completely as a back of an envelope eyeball. So I've just noticed that yes, I look at 9, well 8.87, so we'll call it 9 million. And then you're right, 9 is much less than 40, but actually that's not a fair comparison.
I understand that point, my lord, and in some senses, once my lords reach a conclusion, if you reach a conclusion as to what the basis is upon which interest should be paid, then it will be possible to do the mathematics.
I understand, but it's your advocacy, Mr. Alexander, is what I'm questioning.
I'm sorry, I just didn't...
It's your advocacy that I'm questioning.
Okay, well that's...
You point me to a number, tell me it's very small relative to another number, I fall for it, then my brain eventually starts working properly, and I say, hang on a minute, this number isn't the same.
Well, I'm very happy if the only problem is my advocacy, as it were. If my case is good, I'll take all the blows in relation to my advocacy. My point, though, my general point is remains good in relation to the numbers. And my lord, I'm not in a position to do the precise mathematics, because it depends on what date you choose. If you choose 2007, then the number will change. If you choose 2013, then the number will change. If you these are quite sensitive.
Always upwards, though, Mr. Alexander.
What is the basis for Mr. Mellor adopting November 2018? Is that explained?
I think that's the date of the agreement.
What agreement?
I'm told actually this may be the date of the original offer. But as I might all recall that there was this November offer.
Oh yes.
That was then said to be quantified, because that was one of our alternative cases, which was then withdrawn. That interest should run from that. If interest was to run at all, then it should run from that period.
Why?
Because it was my learned friend's case that was an offer that should have been made, should have been accepted, because it was a Frand offer.
I don't think the judge accepted.
No, he didn't accept it, but he didn't accept it because the valuation was wrong. He didn't accept it because he thought that there was all kinds of other material bound up with it.
But I understand that on this appeal you're asking us to say that no interest should be paid at all.
Indeed.
But you're also asking us to say that if interest is to be paid, it should be paid at a much lower rate.
Indeed.
Are you also saying that we should be paid for a much lower period, much shorter period? So which period and why?
Yes, I'll come on to that in just a moment. Could I just deal first of all with the 4% for the whole period, and then I'll come on to, as it were, the alternative case, which is based on two propositions. One is that that agreement compared on a fair basis, and the other is the conduct case, which needs to be factored in. So, but I will have these points checked, and if I've said anything that's wrong on this, we can perhaps send a note on that. So the next point in relation to rate and period is really that I don't detect a satisfactory response being given to our point that the 4% figure was taken out of an agreement which did not provide for interest to be paid unless it was late, by reference to the payment approach in that agreement. And as we see it, none of the other agreements that are referred to, which have different, I've called them penal clauses, but late payment clauses, operate on a different principle. So the principle upon which they operate is this: none of them provide for interest on what might be called the principal sum, unless the principal sum is paid late by reference to the payment schedule. And in our respectful submission, that is a reasonable approach. It reflects the fact that in these negotiations, it may not be possible to say with complete reliability whether one side has acted in a dilatory manner, whether another side has acted in a non-dilatory manner, whether taken in the round, this is a situation where interest should be payable at all, because it may be said, well, if there has been wrongful conduct, that shouldn't be reflected in an uplift. And parties simply don't negotiate on that basis. And so the agreements that my learned friend has shown you are all in some senses confirmatory of the proposition that I invite my lords to accept, namely that there is no industry practice of providing for interest in the relevant, what might be called the principal sums, but there is a practice of providing for interest upon late payment. Now, my lords, we have no objection, obviously, and indeed it was our proposal to payment of 4% interest for late payment of the sums that this court orders to be paid pursuant to the settled license. Equally, it was our proposal that there should be interest, albeit not at 10%, but at 4% on late payment of the sums pursuant to the schedule that I've shown my lord. But where we do part company from my learned friends is the idea that interest should be paid for the entire period, which is inconsistent with not only the agreement in question upon which the judge based his evaluation, inconsistent with the precursor agreement, and inconsistent with all of the other agreements. And that reflects the fact that this issue that suggested that there should be some compensation on the basis of cost of capital or reasonable rate of return or any of these propositions is simply not accepted in the industry. And there may be very good reasons why it is not accepted in the industry. There are reasonable debates in any area as to the extent to which people should be compensated for risk, for return, for the approach that they take. This court can't say, oh, well, we automatically say that it's correct for there to be compensation on the basis of an assumption in relation to cost of capital. There's been no evidence from the claimant on the claimant's side in relation, for example, to their treasury management policy, whether they ever needed to raise this capital, whether it was necessary for them to do it for particular purposes, whether it was done for taxation purposes, declaring dividends, or whatever. Because there was no evidence relating to this at all. There was no expert evidence on it. There was no factual evidence. And if my lords are going to say, as a matter of principle in a case of this kind, that FRAND agreements have to include interest that compensate a defendant for some asserted notional rate of return in circumstances where that has never been done before in industry, and all of their agreements, or none of their agreements provide for that, that would be going out on a limb just as much, indeed more, than it would be in relation to limitation. People would be saying, well, what is, with all respect, happening? We have a situation where not only is limitation not respected, but an approach to interest is taken, which no one has taken in this case, and indeed no one even took in the preparation of this case up to trial. And we respectfully submit that that would be a wrong approach. So if my lords consider that there is a basis for interest, it ought to be no more than a normal interest. Your lordships can state that if you wish on the basis of the time point that you find appropriate on the limitation aspect, and insofar as the interest time is concerned, we respectfully submit that there are two rational bases. Indeed, the most rational basis, in accordance with the agreements in question, is the date upon which the agreement is ultimately entered into. That is the proper basis of comparison if one's taking the other agreements. And so our primary position is that if one makes a provision for interest, the ultimate sum payable would be zero, because we paid on the dot, or possibly a few days later than the dot, the full claim. And so, and indeed, not only did we pay the full claim, we paid on a basis that we contended not to be an appropriate basis, namely that involved the additional tail of 6
Sorry,
years.
I'm a little puzzled by that. What you say, you paid at worst a few days late. I don't quite understand that, because even disregarding the limitation question, this was a license going back to 2018.
Oh yes, but the question is the date upon which payment should be made of the lump sum, which could only have been made once the court had settled it. It wasn't suggested that it was payable.
So it all depends upon what you mean by late. You
understand.
define late by reference to the date you pay the lump sum, whereas if one defines late by reference to the date when the license started, never mind anything pre-license, you were late by years.
My lord is right, and my lords would have to consider, or could consider that option as well, but that would not be, in any sense, considering a period going back to 2007. So in my respectful submission...
Well, and in fact, in this case, correct me if I'm wrong, it's not that you paid on the date or a few days late. You paid ahead, because you've paid, but in fact the license is not yet in operation.
Well, on one view that is correct, because my learned friends actually haven't offered, in some senses, the license that was settled by Mr Justice Mellor.
There's a debate on that issue as
but
well,
I accept,
as to who's at fault. I understand it's common ground that there is no current license. Each side blames the other.
Yes, I accept that, and I am not saying, my lord, that there is an unequivocally unanswerable date where there can be no room for debate as to whether that is the right date that should be taken. But what I do say is that to take a date that is in any respect before 2018 indeed, I'm reminded the license effectively started in 2023 because one's dealing with a prospective license. But I think that may not address my lord's point, which is that the license
Sorry, I don't understand.
notionally...
That's not an unimportant point, so can you clarify what you mean by it?
So the question may be, if one considers a license to be a permission to do something in the future...
And why should that be? Why cannot a license be retrospective?
Oh no, I understand it could be retrospective, but the question is then how far retrospectively does it go? Because you might say, well, a past part may be not a license, but a past release. I'm just using the term license and past release in the term where they're sometimes used differently.
A license is normally understood to be a permission in return for payment of money.
Oh, indeed.
Why does that not apply just as much to the past as to the future?
Well, you could say that. You could say it's a permission to do and to have done the relevant acts. My only point is that licenses may ordinarily be regarded as prospective.
I'm sorry, I'm really not trying to be picky, but I want to check that I haven't fundamentally misunderstood something. I have been operating on the understanding that the debate at trial was for a licence period starting in 1st of January 2018, going forwards to, I forget when, end of 2024, whatever it was.
Yes.
And as we've seen in relation to the limitation period debate, there was then the question of a notional 6-year limitation period prior to that, which took you back to 1st January 2012. And then there's the question of can InterDigital go back even further? But that was all on the basis that anything prior to 1st January 2018 was strictly a release. It was not a license.
Yes, my lord is absolutely right, and your lordship has indeed understood that correctly. And forgive me if I've introduced terminological confusion on this. I was only seeking to distinguish between prospective and retrospective. My lord is in substance correct, and the licence in question is framed as a licence that is a 2018 to 2023 licence.
My lord, I hesitate to interrupt. My lord correctly summarised the starting point of the parties at the trial, but during the course of the trial and in his decision, the judge took a different approach, and the term of the licence, and one finds this in the judgment attached to the form of order in 283 of the bundle. Excuse me. So it's core bundle, page 283. And if one looks at the definition of term on 1.49, two-thirds way down the page, it's the period commencing 1 January 2007 through to December 2023. And as a consequent, on the next page, clause 2.11 has a grant, and the grant relates to during the term, which one sees 6 lines down in the grant provision. And the licence, I believe, and I'll be correct if I'm wrong, but the licence, I believe, doesn't have a past release, therefore, for obvious reasons.
What about 3.2b? Clause 3.2b looks like a past release.
3.2e.
B. On page 280.
This was about the dismissal of related actions. So it's by the time this licence was being set, and we haven't been through the details, but there were 1 or possibly 2 sets of proceedings afoot in China. There were 2 sets of proceedings afoot in the US, and probably others that I've forgotten. And this was a clause, and there was some debate about this clause in the form of order judgment. It was about dismissing that litigation. It's not a past release as such. So, sorry, my lord, have you?
Well, I mean, it's the first time I've looked at it, but it looks to me like a pretty comprehensive release of all claims, which is fairly comprehensively defined prior to the judgment date. But maybe it doesn't matter. Your point is the term of the licence starts on the 1st of January 2007.
Indeed.
And the royalties payable are payable on sales from that date.
Indeed.
Why 2007?
2007 was when they started trading.
Right.
Or I think strictly to be accurate, it was when Mr Mayor first had evidence of their sales numbers. But I don't think anyone suggested there's much in that distinction, but I just want to make sure the distinction is clear. And my lord, sorry for interrupting, but I was just concerned that it could have been. And obviously there's no appeal as to the term of this licence.
My lord, my learned friend is right, and the original licence that was the subject of the debate between the parties at trial was one where a date was inserted that was January the 1st, 2018, because that was, for obvious reasons, that the structure of the licence was different at that point, in that what was said, the way that it developed was that a licence proposal was put forward, and then the terms were developed in the markup that my lord has seen. But the way that the judge ultimately decided the case meant that he didn't divide this into prospective and retrospective, even though he could have done it like that. So he could have said, okay, well, I'm treating the licence as made on, let's say, the 1st of March 2023, running to the end of 2023, and treated the rest as past release, because it would have amounted to the same thing. The way that he drafted it, ultimately, was to have a licence that extended for the period for which he thought the payment should be made, which was the period from 2007 to 2023. But none of this affects the fundamental point about what the right date is from which to take interest if my lords think that interest should be paid. Because in relation...
So with the benefit of the clarification, could you be clear as to what you say the right date is. I mean, I appreciate you say that you paid, to use a neutral expression, promptly. But the payment date doesn't seem to bear any relationship to anything in the licence the judge has settled.
No, our submission is this: if my lords are not with me in relation to no interest point, that the date from which interest should run is a date equivalent to the date on which interest for late payments would run in other licenses, and that would be the date upon which this license, as settled by the judge, was entered into and required payment. That is our primary submission.
But sorry, I'm obviously not making myself clear. This licence has already expired.
Yes.
And you made your payment not too long before expiry.
Correct.
So I'm struggling to understand, in those circumstances, what you say the dates for interest, as if we're against you. If we say no interest, it's easy. Equally, if we say the judge was right, it's easy. But we're now considering the middle ground.
Indeed.
And you're putting forward a case as to what the correct date range is.
So the date range that would be the equivalent date range.
But what is that? That's what I
Let
don't
me-
understand.
Perhaps I can just answer the question in full, because what date is taken is linked with the interest rate. The date we say that interest should run from for late payment under this agreement is 28 days from execution of the agreement. That is what
Which
is
has still not been executed.
No, I mean that's the difficulty with this point, and
So it's just another argument for no interest.
No, my lords, it is an argument for no interest, but it's a slightly different argument, because we say
You say it's not an argument for no interest. It just so happens on the facts of this case it turns out.
that's correct, because we paid within 28 days of the notional, either the notional execution date or the ultimate execution date, whichever the case may be. But there are alternative options, and that's why we gave my lords an alternative option, which was 2018, which is actually the original date that was proposed for the start of the agreement, which had some justification on the basis that one might say, well, notionally the agreement might have been made at that point. One could say that there are other dates that have a justification, the start of the proceedings. I mean, there are a number of dates that would have justification if one was adopting a late payment rate, because one would then need to say, well, what is the cross-comparable? If one is not adopting a late payment rate taken from other agreements which provide for some and then late payment after execution of the agreement on the payment schedule, then the matter becomes what we might say more at large, and then our fallback position in relation to the level of interest that should be paid is no more than the level of interest that would have accrued had royalties been set aside and placed in a secure interest-bearing account for the relevant period.
Yeah.
So those are our two propositions. Now, my lords may accept either or any of the three of those, or you may say, well, there should be a different one, but those are our positions. And we respectfully submit that they are principal positions supported by the approach taken in the very comparable agreements, including the agreement that the judge relied on, which was the agreement ultimately settled, from which the 4% was taken. Now, if my lords conclude that the right interest rate is a modest interest rate for a period that we submit is the correct one under the limitation point, because the period may be both relatively short and the interest rates during that period, in the way that we respectfully suggest they should be calculated, are likely to be very modest, bearing in mind the level of interest rates in that period. It is probable that issues on conduct and so forth are not going to move the needle very greatly in cash terms on that point. But if my lords are against me in relation to that and say that there should be a late payment rate contrary to the comparables of a level that would not be appropriate and has never been regarded as appropriate, then that rate should properly be adjusted and adjusted downwards to take account of the fact that the claimants essentially in trying to put forward a wholly unjustified claim, delayed the execution of the agreement in such a way that it should be reflected in a reduction of the rate.
Yeah, well, we've got your 3
And I
points.
think my lords have got those points there. Our submission is that they should come to the same point. Because if it's right that the notional, what I call the Huawei rate, is X, it would be very difficult for in our respectful submission, to justify this court saying, notwithstanding that that is the position that is suggested by that case, and notwithstanding the fact that no interest is ordinarily payable on previous sums for these reasons, in this case, the claimants, despite the conduct issues, should be awarded a sum at a higher rate. That would, in our respectful submission, be, I've used the term going out on a limb as we criticise the judge, but we say with the greatest respect that would be penalising my clients for conduct which my learned friend's clients should not have engaged in over the period. And there is no proper basis for an award of interest in that way. So those really are our submissions. And unless I can assist my lords further on this, I think Mr. Segan has one clarification point in relation to some of the evidence. But does my lord have any questions?
My lords, it's a small point of detail, but it may be an important one. It relates to an exchange between my Lord Justice Birss and Mr. Chaxfield this morning about the fact that neither Mr. Meyer nor Mr. Bazant, when unpacking lump sum agreements, and in particular when ascertaining the past element of those lump sums, had applied any grossing up of that amount to reflect the notionally delayed receipt. That approach certainly was common ground between Mr. Bazant and Mr. Meyer, to my recollection. But Mr. Chatsfield then said to you that that was because the experts had agreed that the licenses had been concluded in a distorted market.
And that definitely wasn't agreed.
Quite, my lord, yes. And that was the only point I was going to make.
I think he meant to say that's what the judge's finding was, which is entirely different.
Well, and my lords are very well aware of all my submissions on that.
Oh,
So
yes,
I shan't go back over it. Thank you.
Absolutely.
My lord, can I just clarify one point? It's not on that, and my lord has my submission. I apologise that, again, I misspoke. It was just my learned friend at the end of his submissions was talking about dates. And I just wanted to clarify what's set out in 68 of his skeleton argument, in that he advances page 439 of the bundle. He has and only ever has advanced 2 dates as alternatives. It's paragraph 68, my lords. So you see, 68.1 is the paying no interest at all date, and 68.2 is the
That's
November.
the 28 days he was just talking about, isn't it?
Yeah, that's the one he was just talking about. The other one he did talk about. The problem is my learned friend then went on to raise various other things. The second one he mentioned is 2018, which was related to the November 2018 offer. And that's why when I was very, very briefly addressing my lords, I just said that this part of his case was just a rehash of his behavioural case, because this is all about the offer that could or couldn't have been accepted, etc. But he raised various other points. He talked about the beginning of 2018 as being a date that was proposed at one point for the start of the licence, and he may have raised some other points as well before my lords. And I just wanted to clarify what is the case that has been advanced, and in my submission is the only ones that are before my lords.
All right. So, thank you all for your detailed and interesting submissions. We will reserve our judgments. I'm not going to make any promise as to how quickly they will be handed down, but obviously we will do it as soon as we can. As everybody knows, the usual practice in this court is to disseminate a draft in advance under embargo. Everybody knows the importance of respecting the embargo, to correct typographical errors and attempt to agree in order. And of course, in a case such as the present, to deal with the confidentiality issue. Now, as to that, the draft is almost bound to contain some financial data which is confidential to someone. And therefore, when you get the draft, please look at it and see what redactions are going to be required, as well as what typographical errors there may be. I would hope that that should be a relatively straightforward exercise, because of course you've already gone through the pain, and I acknowledge the pain, of doing the exercise with the judge's judgment, and we've got the revised public version of the judge's judgment, which gives you your starting point as to where to draw the line. So I'm hoping that when you get our drafts, all you will need to do is to compare them with the revised public version of the judge's judgment to see what needs to be redacted and what can not be redacted. All right? Thank you all again.